There's a community called Wayside. It's a small HOA, 10 homes actually, about as small as you can get, right? Self-managed, and they're located in Seminole County, which again, coincidentally, was a county that got hurt. Two owners requested access to official records from Wayside. They wanted insurance policies, they wanted bank statements for the past 2 years, and they wanted records reflecting maintenance expenditures, and upkeep of the individual lots and the common areas. They submitted a request. This is stuff that happens every day in an HOA. They submitted a request by certified mail requesting that they make the records available for inspection within 10 days. That's the law, 10 days.
You'd think Wayside would know when you get the certified letter that you better do something about it.
Well, they didn't. They received the letter, and which meant the deadline for inspection was 10 days later. They attempted to negotiate over the documents, and they wouldn't give it up. So eventually there was a lawsuit filed and there was a trial. At the conclusion of a trial, the court denied the owner's request, believe it or not, for injunctive relief as to the records that requested them. The trial court said they gave you enough. They provided sufficient documents in response to your request, and that the issue is now moot. Even though they didn't give you everything, they basically complied. So association, you're off the hook.
So then we appealed.
Then we went to the appeals court.
You didn't have anything to do with it, did you?
No, this was not my case.
Because you would have appealed it.
This was not my case.
So the appeals court held that the use of the word shall and not
that all the time.
may, the statute means that an association is not afforded discretion in determining which documents to maintain for the inspection of its members or to provide to its members, nor is the 10-day period discretionary. It's 10 days.
It's 10 days.
These obligations are clearly mandatory under the statute. You shall do it.
Right. So I get asked all the time about whether or not owners can see bank statements all the time. We want to see the bank statements. Can you see them? A lot of associations have always said, no, you're not entitled to see the bank statements. Well, on
your
appeal,
money.
You would think, right? And I, always say take the position that they're entitled to them. And on appeal, in this case, the owners argued that they're entitled to see any canceled checks, bank statements showing what the association paid for repairs and maintenance. And here's what the appeals court said. The HOA Act requires the association to maintain these records, and bank statements are included in financial and accounting records, which the Homeowners Association is required to maintain. Therefore, they clearly constitute records that have to be turned over. So bank statements have to be turned over.
Anything that identifies anything financial. Right?
Anything regarded to the operation of the association, yes, especially financial records, especially, you don't know, should be entitled to that. As you know, while you were away, there was even another case in Aventura involving fraud, involving someone stealing from the association.
Turnberry on the green.
Yes.
Mr. What did I say his name was?
Forgot his name.
Oh, he's anyway, he was the president. He was also the managing whatever. He ran the
cook and bottle washer.
Cook and bottle
right.
washer. Yeah.
And long and short of it is, I used to represent them too way back.
But you smelled something rotten.
I'm not going to say that. All I'm saying is I used to represent them way back. Leave it at that.
Well, they said he somehow, Catherine Fernandez-Rundle, the state attorney, says that he took $1.5 million.
It's a good day.
He even used, allegedly, the debit card of the condo to fuel his private plane. And then his attorney said, oh, he's not a flight risk.
And as we, right, exactly. And as we know, condos, you can't have debit cards anymore.
No more.
That's right. And that started, I keep saying this, but why did that happen? Because the debit card was being used to fund the blackjack table at Hard Rock.
That's right.
So no more debit cards. And the same case also held that 10 days means 10 days.